I would note that if these were certified copies, we would not have to go through this process, Your Honor.
I would note that a number of them are certified, as a matter of fact.
Your Honor, if Mr. Stege is making a representation to this court that a number of those documents are certified, I challenge him to show us that right now.
Well, I don't want to engage in this.
No, he made a representation as an officer of the court, as an agent of the state of Nevada, that those are certified records. They are not.
Hey, agreement with.
Where's the rest of them?
Counsel, counsel.
That's one. Where's the other three, Mr. Stege?
Mr. Evenson
Sorry.
and Mr. Stege.
This is the state of Nevada versus two defendants. The state of Nevada versus Roger Eugene Hillygus and Stewart Handte, case number RCR 2019-103-468. Counsel, please state your name for the record.
Your Honor, Steve Evenson for Mr. Hillygus, who's seated to my left.
Your Honor, Tom Pitaro and Kendall Stone for Stewart Handte, who's off to the left of the back there.
Good morning. Excuse me. Good morning, Amos Stege for the state of Nevada.
Good morning. So, counsel, this is the date and time set for the preliminary hearing. And before we begin, I understand this morning there was filed a 5th amended criminal complaint. So let's go forward with the arraignment on that. Mr. Evenson, Mr. Pitaro, has you received a copy of the 5th amended criminal complaint?
About 5 minutes ago, Your Honor, yes, we did.
All right, have you had a chance to review your client's name? Is it correct in spelling it?
It is correctly spelled within the document for my client, Your Honor.
All right, and did you read the 5th amended criminal complaint, and did your client understand the accusations?
I read it, but I did not go over it with my client due to the public setting and being handed it here at the table. I haven't had an opportunity to go over it with him yet.
All right, but has he read it? Does he understand the accusations?
Your Honor, if I could just have a moment.
Of course.
Yes, Your Honor, we understand the nature of the document and what the 2 counts are.
All right, thank you. Mr. Pitaro, I'll have the same questions for you, sir.
Your Honor, we just received it ourselves a few minutes ago. Mr. Handte is looking at it now. His name is correct, so I haven't discussed it with him. I just handed it to him to look at.
All right. Mr. Handte, do you need another moment to review the 5th amended criminal complaint?
No, Your Honor.
All right, so have you had a chance to review it? Do you understand the accusations?
To a certain degree, I do.
Okay, so I'm not asking that you agree with them, just that you understand what they are.
I understand what they are.
All right. Thank you. So I'll waive the formal reading. Any other matters, counsel, before we begin calling witnesses today?
Your Honor, there was a pleading filed by my client under his name, under his signature this morning at 8:48 a.m. I'm asking that the court strike that pleading as a fugitive document. My client agrees with that. He did not consult with me beforehand, and we've agreed that that be struck from the record at this time.
All right. I have not reviewed that. It shall be stricken from the record as a fugitive document.
Thank you, Your Honor.
Counsel, anything else before we begin calling witnesses this morning? Anything
No,
else from
not
you?
for much, Your Honor.
All right. Mr. Pitaro, anything further on
No, Your Honor.
Mr. Stege?
Before we move on, if I can just review the pleading of before it's stricken.
Certainly. And while you're doing that, I'll just make a general announcement to everyone in court and the audience that the court is following the governor's mask mandate. This is considered a public setting. So everyone who is in the courtroom does need to wear a mask pursuant to the court's administrative order, which was filed yesterday, which is in accordance with the governor's directive.
Your Honor, could I inquire the 6 feet, how we're going to sit the way we are now, or we're going to have to move, or?
So I don't believe
I'm not sure how we're doing it up here.
So here, it's my understanding that the mask mandate is in place. However, there have not been reinstated social distancing requirements. Certainly, if you're uncomfortable in any way, we can make accommodations to provide the distancing. However, if you do not wish that, you can simply remain as you are.
I'm willing to accommodate room for, I just want one small room over there.
All right. Doesn't sound like there are any requests at this time to make more room, but please, if at any time you would like us to make more room for you, I'm happy to do so. Mr. Stege, just let me know whenever you've had a chance to review that.
I have, thank you very much, Your Honor. I'm ready to proceed. I don't object to the request of Mr. Evenson.
All right, so it shall be stricken. Council, I assume the rule of exclusion is going to be invoked, is that correct?
It is, Your Honor, thank you.
All right, so what this means is anyone who is in the courtroom who has the potential to be a witness in this case, you will have to step outside in the lobby. The only people who are going to be allowed in the courtroom are those who are not witnesses in the current witness testifying. And those witnesses who have to have a seat out in the lobby, they cannot discuss their testimony with anyone. Mr. Stege, who is your first witness you'd like to call?
Oliver Miller, please.
All right. Good morning. If you please proceed to the witness stand. Once you get there, I will swear you in.
Thank you.
Will you please raise your right hand? Do you promise the testimony you're about to provide today will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Please be seated. Go ahead, Mr. Stege.
Thank you. Your Honor, may I remain seated for my examination?
Certainly.
Thank you. Please state and spell your name.
Oliver Miller, O-L-I-V-E-R, Miller, M-I-L-L-E-R,
How are you currently employed?
by the Reno Police Department.
In what capacity?
And the Deputy Chief of the Community Services Division,
And how long have you been with the Reno Police Department?
18 years.
I'd like to direct your attention back to July 29th, 2019. Did you have occasion to speak with someone identified as Roger Hillygus?
I did. May I remove this while I speak?
So there is a mandate in place that we need to wear masks in the courtroom. It is a public setting, so we're following the governor's mandate.
No worries. Your
I'm
Honor.
sorry, if you need time or just lean forward to speak more loudly, that's totally understandable.
Yes, ma'am. Sorry.
How was it that you came into contact or had a phone conversation with Roger Hillygus?
On or around July 29th, Mr. Hillygus had called into our executive team's pool and tried to reach Chief Soto. I was advised by
Your Honor, I'm going to object. That appears to be hearsay testimony unless he directly took the call and talked directly to my client. It appears as if he's speaking from administrative records.
Mr. Stege?
I don't believe that's speaking for administrative records. I think he's speaking non-hearsay in that it's not admitted for the truth of the matter, but explaining that he called back or why he had a subsequent conversation with Hillygus.
So given that it's not for the truth of the matter and it's from this own witness's personal knowledge, I'll overrule the objection.
I received notification from our administrative secretary that Mr. Hillygus had contacted and left a message for Chief Soto. Chief Soto was out of the office, so I returned the call on his behalf.
And please describe the conversation.
I spoke with Mr. Hillygus, and he informed me that he was seeking to speak with Chief Soto about assisting him in aiding him in getting his mother out of a local care facility.
At the time, did you know what facility, or did he reference which facility?
He did not.
Please continue.
I spoke with him and got some of the details. He informed me that he was awarded a jury verdict for being the executor of his mother's estate, and that he wanted to retrieve her from that care facility. And during our conversation, I was trying to get more details about which care facility it was, but I wasn't able to get that far with him. He also informed me that he had been trespassed from the property within the past year, and that he was unaware of the trespass was still in effect. Based on that, I let him know that it was a civil matter, and that the Reno Police Department nor Chief Soto could assist him in retrieving his mother from the care facility and taking her out of their care and custody, that he would have to contact management, begin there, and probably work through the civil process by hiring an attorney.
Did he mention the name of Sheriff Darren Balaam during your conversation?
He did. He wanted to have myself, Chief Soto, Sheriff Darren Balaam, go down there to effect some type of civil arrest against the individuals that were holding his mother in the care facility, as well as a show of solidarity.
And in fact, did he use the term citizen's arrest, that a citizen's arrest occur against the personnel at the facility?
He did.
Please continue.
I let him know that, we had no authority to remove an elderly person from a care facility, and again, reiterated that, we needed to contact management there to not go there in person, just in case his trespass was still in effect, and to hire a civil attorney. He also mentions Mr. Stu Handte, and that how he had agreed to already assist him through this process by going down there in person to getting his mother, Susan Hillygus, out.
And to clarify, you mean that Hillygus mentioned that Handte had already agreed to help him out in this process? Was that name familiar to you, Stu Handte?
It was.
And in what way or how?
He was a former chief of police for the Reno Sparks Indian Colony.
And so you knew Mr. Handte in sort of a professional capacity?
I did.
So we left off, you warned him, hey, to get a civil attorney, and warned him against trying to remove his mother. Is that accurate?
I did.
Did you give any warnings about the trespass issue, if that was still valid?
I did, and that's why I told him to contact the management via phone instead of going in person.
And did he ultimately agree that he would, in fact, call the manager of the facility and update them on the status of, or his claim?
He did.
Did he further agree that he would obtain an attorney if the facility was not able or willing to assist him?
Your Honor, I have to object to leading questions at this point.
Mr. Stege?
I'll ask it in a non-leading fashion.
All right.
Did Mr. Hillygus make any statements about whether he would get an attorney in the future?
He did.
Do you recall what he said?
It was near the end of our phone call, and he agreed, yeah, I will look into getting an attorney to assist me through this process, something to that effect.
Let's move forward to the next contact with either Hillygus or Handte, and we'll talk about August 7th. Can you tell us about what occurred on that date?
On August 7th, I had a conversation with Mr. Handte. He had reached out to our executive pool secretary, and she contacted me, and I was aware of the issue that Mr. Hillygus had, and I agreed to recontact Mr. Handte because I knew about the circumstances.
Can you describe the contents of that conversation, please?
Yeah. Mr. Handte wanted to get assistance from the Reno Police Department, in particular Chief Soto, to go down to Mr. Hillygus' mother's care facility to assist him in removing her from the care facility. Mr. Handte relayed to me that Mr. Hillygus was awarded a civil jury verdict, essentially awarding him custody and care of his mother.
And so was Mr. Handte essentially making the same claims or similar claims that you had heard from Mr. Hillygus?
He was.
Please continue.
During our conversation, I informed Mr. Handte that, I was a little more than concerned with Mr. Hillygus attempting to remove his mother from the care facility, and I informed him that what also concerned me is that he wanted to effect citizens' arrests on some of the staff members there. I informed him of what I informed Mr. Hillygus, that we as law enforcement could not remove an elderly person from the care and custody of a care facility, and that it was a civil matter, and that he would have to hire an attorney to help him work through that civil process.
Did Mr. Handte relate anything in his own background that caused him to want to assist Mr. Hillygus?
He did. He said his own mother was held by a care facility kind of in the same manner prior to her death, and that this was the reason he wanted to assist her through this process.
What was Mr. Handte's reaction to your assertion that the case ought to be handled in a civil manner?
He really wanted to help out Mr. Hillygus, who I assumed was his friend, because of the close circumstances. But ultimately, he agreed that he would talk to Mr. Hillygus about the recommendations I made to him.
Did you mention to Mr. Handte Mr. Hillygus's assertion about having been trespassed?
I did.
Did Mr. Handte ask anything else about related to sort of professional matters?
He did tell me that he was interested in seeking another job in law enforcement. And I told him that if he was, and if that was the plan, because as far as I was aware, he was no longer in law enforcement with the Reno Sparks Indian Colony, that he would not assist Mr. Hillygus by going down to the care facility in person and removing Mr. Hillygus' mother, Susan.
And approximately how long was this conversation, this phone conversation with Mr. Handte?
I believe I was on the phone with him for nearly 20 minutes.
Let's move forward to August 8th. Was there a phone conversation with Mr. Hillygus on that date?
There was a phone conversation with Mr. Hillygus again. I was made aware that he had contacted our executive secretary wanting to speak with Chief Soto. Chief Soto was out of the office, so I spoke with him, knowing the circumstances of the circumstances of what he was requesting. During our conversation, I do recall it was pretty short. I think maybe 2 to 3 minutes. He reiterated that he had not or was not interested in contacting the management of the care facility as I recommended, or hiring a civil attorney to work him through the process, and that he wanted to go down and pick up his mother from the care facility. And again, I informed him that, that wasn't an appropriate course of action, that he indeed needed to contact the care facility via phone to confirm that number one, management was on site and that he could actually speak with them. And number two, that he did not actually have a trespass that was valid in getting him cited or arrested from there. And that this is indeed a civil matter and needs to be handled through a civil attorney.
Any difference in sort of the tone with Mr. Hillygus of the first and the second calls?
Yeah, he was a lot more short with me, and I believe that the conversation culminated with him hanging up on me.
Thank you. What's the next thing to happen?
Later on that same day, on August 8th, I received a phone call from the watch commander. I believe it was then Lieutenant Sean Garlock, informing me.
Your Honor, I'm going to object to hearsay at this point. Again, I don't know what he's going to say or how deep he's going to go, so I can't unring the bell.
Mr. Stege?
Again, same response. The issue of ringing a bell, I think, is of almost no consequence in proceeding of this manner. It is not offered for the truth of the matter asserted.
So I agree, I don't believe it is offered for the truth of the matter asserted. I believe this witness is simply laying some foundation about what actions he took. So for that purpose, and not the truth of the matter asserted all about it.
So, I'm sorry, Sean Garlock, lieutenant or another command level person later contacted you.
Well, prior to that, if I could, I met with the administrative secretary, Patricia Medina, and informed her that if Mr. Hillygus were to call back to let me know. She neglected to tell me on the front side of our conversation before I called him that he said he'd be coming to the Reno Police Department. So I informed our lieutenant in charge of the watch to ensure that either he or a sergeant meet with Mr. Hillygus and hears his issues and concerns, a civil matter, if he were to come to Reno PD. Later on that evening, when I spoke with Lieutenant Sean Garlock, I learned that he had come to the Reno Police Department and that it was one of our sergeants that met with him who took a report on basically his concerns.
And so you basically issued an order to your staff that a sergeant, if Hillygus were to appear, a sergeant was directed to speak with Hillygus and that it was a civil matter.
Yes.
Let's move forward to the later in that evening. Was there a report that came into RPD related to Mrs. Hillygus?
Yes, I was contacted by Lieutenant Sean Garlock, who informed me that Mrs. Susan Hillygus had gone missing from the care facility and that they suspected Roger Hillygus was involved.
And did you provide any information to Garlock
I
about
did.
Hillygus?
I informed them of everything I knew, and I provided him with Mr. Stu Handte's phone number in an effort to contact him because he had been law enforcement to assist in locating Mr. Hillygus.
Did you yourself leave any messages for Mr. Handte?
After I was informed by Lieutenant Garlock that he could not reach Mr. Handte, I myself did leave a message for Mr. Handte to return my phone call. I believe I received that phone call from Mr. Handte later on in that evening, maybe 2 hours later, sometime after 10 p.m.
And what was the content of that conversation?
He called me and I asked him, you know, did you go with Roger Hillygus to take his mother from the care facility? And he said yes. I asked him if he knew where Roger was and he could describe the vehicle that he was driving. He also told me yes. He went on to inform me that they did not kidnap her from the care facility and that the workers, the staff, had waved goodbye to them as they both left.
And up until that point, had you yourself used that terminology, kidnap, or was that something that Mr. Handte injected into the conversation?
I had not used the term kidnap.
Then around this time, was there in fact an investigation ongoing by members of your staff, officers and detectives?
There was. I requested that Mr. Handte make himself available and that Lieutenant Joe Robinson would be coordinating with him to assist in locating Susan Hillygus and Roger Hillygus.
And did Mr. Handte say whether he was willing to assist in locating Mrs. Hillygus, I'm sorry, Mr. Hillygus and his mother?
He did.
Thank you. I'll pass the witness.
I've been a pretty lucky guy. I know you asked for just a little bit of background, but what comes to mind is that, well, I started my life.
I'm going to make a record about you in a minute. You need to sit down and be quiet.
For those that don't know me, which is be difficult in Nevada, my name is Judge Cheryl Moss. I served in Family Court, Department I, and from
For the record, I don't say these things to hear myself talk.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
In the dependency arena, you really do boil down what the best interest of the child actually means. You could have a party arguing,
Ask the question, make sure we're being accurate with what the document means.
All right, then we'll turn to you, Mr. Evenson, unless council has an agreement about who would like to proceed. Mr. Stege, I'm sorry, if you could just replace your mask, thank you. Go ahead, Mr. Evenson.
Thank you, Your Honor. Just a few questions for you there, Deputy Chief. Relative to the first phone call you received on July 29th of 2019, did you make a report when that call came in?
No, I didn't.
Did you take any notes you put on a computer or a notepad or anything like that?
I don't recall.
Okay. Not recalling would indicate it's possible. Did you ever seek or try to find out any of those notes as this case progressed?
I know that I often take notes in my role. I was a commander at the time, so I may have referred to notes in drafting my Tiburon supplement.
Okay. And have those notes, to the best of your knowledge, been provided to the district attorney's office or to anybody to this date?
My Tiburon report, my case report has. No notes have been provided.
Okay. And so, and are those calls that come in, or is every call that comes in, because I don't know your agency as well as I do some others, are they recorded?
No.
Okay. So what distinguishes a call coming into your agency that's on a recorded line versus one that's not on a recorded line?
911 is a recorded line. Our dispatch, I believe, even the non-emergency lines are recorded, but none of the internal lines into the Reno Police Department are recorded. And I think that comes down to a matter of need.
Sure, I understand, and I'm just asking because I honestly don't know, so forgive me. But with regards to the process of this call, do you know if it came in through dispatch and then went through to another line, or to your executive staff, as you put it?
I have no idea of how it came through.
Okay, so it is possible that at the time it was recorded, but obviously, I imagine you don't hold on to recordings for over 2 years.
Yes, and if our dispatcher did pass a recorded phone call through 911, the recording would stop once the dispatcher hung up her or his side of the phone.
Okay, but if it came in on a non-emergency line to dispatch and then was ferreted out to whomever?
It still would, the recording would end once the dispatcher's phone portion, once they release the call to our internal number.
Okay, so that ends the moment that that call is released, the recording stops?
Yes.
If any, okay. And then, same question with regard to the phone call of August 7th, when you talked to Mr. Handte for the first time. Did you make notes on that? Did you make any written reports at that time?
I may have made notes for my written report, just noting that the time and date that I spoke with Mr. Handte.
Would that entail any details of the conversation?
I don't recall, not
Okay.
necessarily, but I do not recall. 2 years.
Your recollection of the phone calls, all three of them, appear to be pretty detailed and specific, which is why I'm asking these questions. If you don't have a written report made at the time and you don't have the recordings to listen to, is there something about these calls that stuck out in your memory that way, or are we getting the perception after all of this took place?
So when I made my report, it was pretty close to the time that this incident had occurred. So the reason it sticks out in my mind so well is because of the level of request that he had. He actually wanted certain things like myself, Chief Soto, Sheriff Balaam going to the care facility to show solidarity. You know, those things happened within a week of my writing the report, so they were pretty fresh in my mind.
But so those things you remember, but in terms of the exact details of what my client was saying, you've been pretty clear you don't remember those kind of things.
No, I've been pretty clear. I don't remember if I took notes on them, but I recall exactly what he said to me.
And then with what took place on the 8th and the 9th, I just want to be clear, I don't believe you ever spoke to Roger after the 29th, is that correct?
Mr. Roger Hillygus?
Yes.
I spoke with him on the 29th and I believe on the 8th.
On the 8th?
Yes.
Okay. And I note multiple times within this, you call this a civil matter, is that correct?
I did.
Okay. And multiple times within this, you told him to go into the civil court system to do what you felt he needed to do.
So I told him to hire an attorney to work through the civil process.
Correct. Do you know exactly what the civil process is?
I do not. That's why I hired an attorney.
Right. I understand that that's the advice, but you don't have any knowledge of the civil process to say he did anything wrong or right on the civil side of things, do you?
I can speak to the criminal process, not to the civil.
Correct. So you're not offering any comment about anything on the civil side of things?
That's correct.
Okay. And after your contact with my client on the 8th that you indicate, you didn't have any contact with him after that date, after the 9th, yourself?
I did not.
Okay. And when Roger was contacting you about these things, and then Mr. Handte said that he was concerned about this situation becoming like his mother's, it would appear from the nature of those conversations that my client and Mr. Handte were generally concerned about the welfare of Susan Hillygus within that facility. Is that a fair way of putting it?
No.
You don't think they were concerned about her welfare?
I think the concern was that he had a jury award for her custody and he wanted to execute that. I did not take away that he was concerned for her welfare inside the custody.
Well, let's assume that he got the jury verdict or whatever that he's talking about or that you're referring to. Let's assume that was obtained by some method. Do you know what he said to obtain that? Do you know what was done to obtain that?
Objection, speculation.
Well, let me rephrase that. Do you know what the basis was for him obtaining that order?
No, he never told me.
Okay, did you ever ask?
No.
Okay, so it is possible then that he was motivated by a genuine concern about the welfare of his mother throughout this whole process.
I'm sorry, Mr. Evenson. Speculation as well.
Well, I'm asking.
What is possible is
Well, that's why I'm asking whether or not it's possible, because he didn't investigate that. That's the point of the question.
So I don't think that that's calling necessarily for speculation. We're talking about mere possibility.
So again, may I proceed, Your Honor?
Yes.
Thank you. So again, Deputy Chief, it is entirely possible that his sole motivation here was the welfare of his mother.
I don't think so.
Well, I understand you don't think so, but I'm asking whether or not it's possible.
Same objection.
No.
I mean, anything's possible.
Okay, so you don't even think it was possible?
Objection.
So, and I think the point has been made. I think the witness has answered, so let's move forward.
Okay. Your Honor, may I inquire when he answers no to it being possible? I wanted to ask a follow-up question whether or not it was, but I understand where you're going. Okay, I won't beat that horse. Thank you, Your Honor.
Thank you. Mr. Pitaro.
Thank you, Your Honor. Chief Miller, it appears from your testimony that Mr. Hillygus informed the Reno Police Department what he was planning to do concerning his mother at Stone Valley. Is that correct?
He was asking or requesting us to assist him in going to the care facility to help remove his mother.
So he told you that he wanted to go to Stone Valley and remove his mother.
He did.
And Mr. Handte also told you the same information.
He did. He requested our assistance, yes.
And they both requested the assistance of the Reno Police Department to aid them in removing Mrs. Hillygus from the facility, correct?
Yes.
And you told Mr. Handte and you told Mr. Hillygus that it was a civil matter.
Yes, and I told him that we have no authority to remove his mother from said care facility.
You said it was a civil matter.
Absolutely.
And you didn't tell him his removing his mother would be a criminal matter, did you?
I told him that.
But did you tell him that it would be a criminal matter? That's my question.
I told
Did
him.
you tell Mr. Hillygus that it was a criminal matter?
Yes, and as so much as if he went down there with a trespass order in effect, that he could be held criminally culpable for that. But did I say kidnap or anything like that? No.
Well, all right, you confused me because you seem to have merged two things. I'm talking about the issue that Mr. Hillygus wanted to remove his mother from the restaurant. You did not tell him that would be a criminal matter, did you?
No, I told him it was a civil matter.
All right. Specifically, you told him that. And you, let me ask you, you were aware that other members of the Reno Police Department also informed Mr. Hillygus of that same fact, that it was a civil matter?
Judge and hearsay.
Mr. Pitaro?
Well, I don't believe it's hearsay, Your Honor. He opened it up when he testified as to what it was, and I'm asking him, not as a truth of the matter asserted based upon him as a representative of the police department. I mean, here, okay, I think that's clearly the issue, because what it does, Your Honor, on both Mr. Hillygus, who the Evenson can represent, but Mr. Handte, this goes to the issue, obviously, of intent, which are elements of these offenses. And so that's what we're trying to establish, because they've alleged not only a conspiracy, but a robbery.
Your response, Mr. Stege?
Alas, still hearsay, and specifically admitted for the truth of the matter that he was told it was a certain type of thing, or was not a criminal matter. As well, assuming it is not hearsay, which it is, it's entirely irrelevant, right? There is no, get to ask a police officer, hey, do you mind if I go do this, right? That's not how our system works. There is no sort of free pass, because if, say, an officer gives a mistaken opinion about a law, that does not excuse you from criminal liability.
My response, of course, that has nothing to do with the question of what we're talking about. What we're talking about is in the conspiracy count, the state is alleging that these two gentlemen engaged in a conspiracy, and that conspiracy took place prior to them going out to this facility. So that's one. So the issue of their state of mind is important, and their state of mind, of course, exception to the hearsay, is based upon what they were told. Whether it was true or not doesn't matter. It goes to the issue they were told that, and that affects their state of mind as to conspiracy. It also has the effect as to the burglary, because the burglary is alleging the same thing. In the new complaint, they put in conspiracy as well as that. So what we're talking about here are two men who asked the police department concerning help on this, told exactly what they were going to do, and they were told multiple times, as he's already testified to, by the way, that this was a civil matter.
Well, I believe what was testified to previously was simply some steps that were taken in order for this witness to return phone calls. Now, I believe the question is related to what this witness believes someone else told potentially the defendant. So on that basis, I think that is hearsay.
Well, could I just respond and I'll let it, Your Honor, he is the person that is directing the other people to do this. He is the one that is the deputy chief who is directing down the chain for ultimately Sergeant Hannafin to make those statements, which we will obviously get into, as we all know, as we go down.
And I think he can certainly speak to what he had others do on his behalf, but not necessarily what those others may or may not have told someone.
Did you direct these people to inform?
Now, Your Honor, may I respond? We just had a very long narrative, sort of closing argument type response.
You may, but
to my
again,
objection.
in that vein, let's keep it
Right.
tight to the objection.
It's still hearsay. It is still hearsay, and now it's brought in the issue of his client's own state of mind is always off limits in terms of hearsay unless the defendant himself is saying the word. So it's we have like 4 levels of hearsay.
Correct,
here.
and Mr. Stege, I just ruled that it was
Right.
hearsay.
And so the issue of what he had others do on his behalf also gives to hearsay, and I would suggest the court limit its ruling to what was the order given? What order was given to subordinates as to the subject at hand?
And I believe that's what I am limiting it to. Again, he can testify as to what he had others do, but not potentially the others may or may not have said or things of that nature. But he can testify to what steps he asked others to take.
Did you in fact ask other individuals at the Reno Police Department to meet with Mr. Hillygus?
I did.
And did you advise them that you had already spoken to Mr. Hillygus?
I did.
And did you also advise them that you had already told Mr. Hillygus that this was a civil matter and the Reno Police Department was not going to get involved?
Unless any new information came to light, yes.
Okay, so you did tell them that?
Yeah.
Okay. Now, and to the best of your knowledge, your directives as the deputy chief were followed by your subordinates?
Yes.
Okay. Now, you then, concerning this issue of a civil matter, Mr. Evenson pointed out that you don't know what the concept of the civil process is. So what you were telling Mr. Hillygus was a suggestion, correct?
Yes.
Okay. And what you told Mr. Handte was a suggestion.
Yes.
Now, you were made aware that there was this document that Mr. Hillygus said that he had, which dealt with a jury verdict giving him custody of his mother, correct?
Yes.
All right. Did you ever ask to see that document?
I had only spoken with him over the phone, so no.
Did you direct any of your subordinates to look at this document and take a look at it to see what it did or did not say?
I requested my subordinate follow up with Mr. Hillygus if he were to respond to the RPD main station, and to my knowledge, that was accomplished by Sergeant Hannafin.
Were you aware of whether or not Sergeant Hannafin, based upon your direction down the chain, saw this document that Mr. Hillygus was referring to?
Objection, speculation, lack of personal knowledge, and hearsay.
I've asked him, does he know? Can't think of it.
It still calls for those 3 things.
So I think this witness can testify to his personal knowledge about the issue. You can answer.
Can you repeat the question, please?
All right. We're good. All right. Were you aware of this document being furnished, if you will, to any of your subordinates based upon your direction to meet with Mr. Hillygus?
I don't know if my subordinates reviewed the document.
Did you ever ask them if they had reviewed it?
I did not follow up with them.
Did you ever, are you aware that this document had in fact been filed with the Washoe County Clerk's Office?
Objection, lack of personal knowledge, relevance as well.
I think he, again, is speaking about his personal knowledge. Whether he has that or not, we don't know. But I think he can talk about whether or not he knows if a document was or was not recorded.
I do not know if the document was recorded.
Okay. Do you know if this document was filed with the Washoe County Assessor's Office?
I do not.
Thank you. And you made no attempt to look at this document yourself?
No.
Now, when you spoke with Mr. Handte, he told you that the reason he wanted to assist Mr. Hillygus was because it reminded him of the experience he had had with his own mother.
He did.
And he relayed to you that he was upset with what had happened to his own mother vis-a-vis another rest home.
Yes.
Okay. And so at least it's definitely, as far as Mr. Handte, he was concerned with what was happening to Mrs. Hillygus because he was relating it what had happened to his own mother. Correct?
The similar circumstances, yes.
Okay. Now the other thing is you said that you had asked Mr. Handte when he called you back the night of the 8th, I believe it was, of August, correct?
Yes.
You asked him if he would cooperate.
Yes.
And if he would assist the Reno Police Department in trying to locate Mr. Hillygus and or his mother.
Yes.
And Mr. Handte, he said that he in fact would.
Yes.
So he had answered in the affirmative that based on your request, he would cooperate.
Yes.
And you told him that you were going to have Lieutenant Robertson contact him?
Yes.
Are you aware of whether or not Officer Robinson or Lieutenant Robinson ever did in fact contact Mr. Handte?
I was informed that he was not able to make contact with Mr. Handte.
Ever?
That evening.
Just that evening then? Okay. And did in fact, are you aware, based upon being a deputy chief involved in this, Mr. Handte did in fact attempt to make contact with Mr. Hillygus based upon your request?
Can you repeat the question one more time?
Are you aware, as deputy chief who had had this conversation with Mr. Handte concerning cooperation, that Mr. Handte in fact did make attempts to contact Mr. Hillygus?
I'm unaware.
You're unaware of that?
Yes.
You had referred to, and it doesn't necessarily affect Mr. Handte except for the fact that you mentioned it to him, and that was concerning this trespass. Had you ever seen a trespass warning given to Mr. Hillygus?
No.
Did you ever make any inquiry through the Reno Police Department if in fact one had been issued?
No.
And you were aware that the trespass warning has certain statutory requirements, correct?
Yes.
All right, so you made no attempt to ascertain whether that was true or not?
I didn't have the information, so no.
I'm sorry?
I didn't have the information of when it occurred or where. I didn't even know the name of the care facility. I was going by Mr. Hillygus's word that he informed me that he'd been trespassed from there within the year.
So your statement concerning the trespass to Mr. Handte was, if there is one, then obviously if there's a trespass warning, that can then be a misdemeanor offense?
Yes.
Okay. But you have no idea whether that was or wasn't correct?
No, other than his statement to me, no.
And you didn't ask Mr. Handte if he knew one way or the other either, did you?
No.
All right. If I could have 1 second. No further questions, Your Honor, thank you.
Your Honor, if I could just follow up with a couple of trespass questions real quick, because I didn't ask any, and then maybe we won't have to do a redirect and a recross, if I could just have that leeway.
All right.
Briefly. Thank you. With regard to this issue of trespass, Deputy Chief, is it possible, was the only time that that was discussed during the July 29th phone call?
No.
With Roger. With Roger. The only time it was discussed was with the July 29th phone call.
I believe I discussed trespass with him on the 29th and the 8th.
And the 8th, both days. And at that time, when you discussed trespass with him, you indicated that he said he had believed he had been trespassed. Is it possible that the conversation was actually that he was concerned he would be trespassed, as opposed to actually already having been?
He informed me that he'd been trespassed.
Okay, did you ask him what he meant by that?
No.
Okay, and with regard to that, and the statutory requirements for a trespass, I mean, I'm not gonna go through them with you, I don't know what your knowledge is of NRS 207.200. But it indicates that there are several ways of doing that, the last one being a written warning or an oral warning for somebody in control of the property or words to that effect. Did you know if that had ever happened?
I did not.
Okay, and did you ever ask him exactly what he meant by being trespassed in his own mind?
No.
Okay, I have nothing further, Your Honor, thank you.
All right, Mr. Stege, for any redirect?
Yes, beginning at the end there, that been trespassed or using trespass as a verb, that is sort of a jargon that is used by people in the community that we're involved in, right? Law enforcement, criminal justice related folks.
Objection, Your Honor, calling it jargon, it's a statute. It's not jargon, it is or it isn't.
Well, the statute is trespassing. The using trespass has been trespassed as a verb is jargon in the legal community and criminal justice community. In contrast to lay people do not say trespassed. They don't use trespass as a verb. That is the heart of this question.
Mr. Pitaro?
I'm confused. That made no sense that we use it as jargon and it is or it isn't something. We're talking about a specific thing where this deputy chief mentioned that you may have a criminal liability if in fact there's a valid trespass warning.
Well, at this point, I think we're simply talking about different interpretations of a word. I'll allow those questions, and obviously, and any of these things can be argued.
Right. So the term used by Hillygus was that he had been trespassed, correct?
That's correct.
And you used that terminology to tell Mr. Handte that Hillygus had said he had been trespassed.
That is correct.
Does the Reno Police Department enforce jury verdicts of any sort?
We do not.
Did either defendant ask you to investigate or start an investigation as to abuse and or neglect of Mrs. Hillygus?
No, and I think if that were their primary concern, they would have actually used the words, I believe she's being abused,
Your Honor,
neglected.
I would have to object. He's speculating now as to what one or more might have meant if they had done this. They either did or they didn't. He doesn't get to speculate what he thinks it is.
Mr. Stege?
It was just asked about, from Mr. Pitaro at length, about sort of the question of what was in the defendant's mind about this three people down saying it's a civil matter, handle it civilly. Same sort of idea, which is this determination of intent.
Well, and I think the questions are fair as to what was stated or what was not stated, but I do think it is speculation to speak in the way that Mr. Pitaro was referencing. So I'll allow it for some purposes, but not the other.
So did either man ask for an investigation into abuse or neglect?
No.
Ms. Hillygus?
No, sir.
Or ask of an investigation into the facility of any kind?
No.
In essence, they were asking for the police to help them go get her out.
Yes.
To essentially force the facility to release or to let them take her.
Yeah, a show of solidarity.
Mr. Pitaro used the term that the directive was to not get involved. Wasn't the directive that we are not going to force the place to give over Mrs. Hillygus?
That is correct.
Put it a different way, you're not, it was never your directive to give them a free pass to do whatever they wanted, but the directive was tell them.
Your Honor, that's a leading question.
It's allowed on redirect.
attempt to drill down.
What rule is that?
Okay.
And once again, and also it calls him to, once again, speculate as to what is or isn't in other people's mind.
I think he's asking this witness what this witness was indicating, not what the others were thinking. So I will allow this witness to testify about what he was thinking at the time. Given
Your Honor, with all due respect, what he's thinking is irrelevant. I don't care what he's thinking, it's what he said, not what he's thinking. He could be thinking of a lot of things, but his thinking as to when he says something is not relevant to anything, because he could be thinking a lot of things. He could be thinking when he's saying these about ordering pepperoni pizza. The point of the matter is his speculation.
Counsel, could we please not speak over each other? It's very difficult for me to listen appropriately when people are speaking at the same time. So go ahead and finish, Mr. Pitaro, and I'll turn to Mr. Stewart.
What I'm saying is, Your Honor, what he is thinking, what he is not relevant, because we don't care what he's thinking. What we care about is what he may or may not have said to the two defendants, either individually or jointly.
And if I reference the word thinking, what I mean is the basis for which this witness was making a statement. Mr. Stege, I'll turn to you for your response.
Right, well, of course, it was just injected into this proceeding that there was sort of this idea of interpretation or misinterpretation of directives on behalf of the defendants. That is a two-way street. They are not free to misconstrue or have interpretations or speculate, ask speculative questions about what was in the defendant's mind if the reverse is not true. What was your intent? And there's an evidentiary hook for this, which is then existing mental or physical condition in stating this is a civil matter. They're trying to construct a defense that they were given a free pass, like you can do what you want, we're not going to get involved, which is terminology used by Mr. Pitaro, which is ambiguous as stated in the question.
That can't be a question.
That was your question.
Your question to this witness. Objection, the question doesn't make any sense to me then. If what he just said is what the question is.
Mr. Pitaro's not following is not how this should work. I don't follow is not a proper response to the objection.
And Mr. Stege, can you just restate your question, please?
Was your intent in giving directives to your subordinates that this was a civil matter to give either man a pass to take Mrs.?
Your Honor, I think the best stated exception on that is what Mr. Pitaro said a couple of minutes ago, that his intent in what he said is irrelevant. It's what these gentlemen heard and what they believe. His intent in what he said is irrelevant.
Well, to the extent that it is, there's ambiguity as theorized by the defendants, it is appropriately before the court.
And again, I think many of these issues that counsel are bringing in are appropriate for argument, not necessarily questions of these witnesses. So I don't know that getting into people's different interpretations of things is appropriate. I think we need to limit the questions here to what was said, what was done by this witness. So given that and given all the argument I've heard in totality, I am going to sustain the objection.
Sir, did you ever direct that RPD was not going to get involved in this matter?
Repeat the question one time.
Did you ever direct that RPD was not to get involved in this, anything that were to happen as a result to Mrs. Hillygus?
No.
Was there a contrast in sort of the tone, your last conversation with Mr. Handte, where he agreed to assist, and the earlier requests that RPD enforce or assist in removing Mrs. Hillygus?
Contrast in the tone?
In the tone or the mood or the
demeanor of Mr. Handte?
He was quiet.
Thank you. No further questions.
Your Honor, I do have, I'm sorry, Steve.
I'll let Mr. Pitaro go first since he jumped up, if that's agreeable with the court.
Certainly, go ahead, Mr. Pitaro.
Thank you.
Deputy Chief, you were asked on redirect if Mr. Handte or Mr. Hillygus made any statement for investigation of Mrs. Hillygus's status at the restaurant. Remember that question?
Yes.
All right, now isn't it true that when you spoke with Mr. Handte on August 7th, he specifically told you that the care facility was holding Mr. Hillygus's mother unlawfully?
No.
And isn't it true that he told you that the care facility was holding Mr. Hillygus' mother against her will?
Actually, unlawfully and against her will could have been his words, yes. Yes to both, potentially, but I would have to review my case supplement.
Your Honor, may I approach, or how do we want to do it here? Give it to the bailiff, or?
So if you're asking him to review his report to refresh his recollection, you can approach the witness with the report as long as, and just let Mr. Stege know what you're referencing.
It's the Oliver Miller statement.
Thank you.
Deputy Chief, if I could direct your attention to 1, 2, 3, 4. Fourth paragraph down, 1, 2, 3, fourth, fifth, and sixth sentence, and ask you to look at that.
Fourth paragraph.
See it down there? I tell you what, I'll put my finger on it and make it easier for you.
Perfect, thank you. Thank you. Yes.
So, let me just go back to my question, if I may. Isn't it true that Mr. Handte told you that the care facility was holding Mr. Hillygus' mother unlawfully?
Yes.
And he also told you that the care facility was holding Mr. Hillygus' mother against her will?
Yes.
So, based upon him stating that to you, did you conduct any inquiry as to whether or not that was correct?
Yes.
When did you do that?
During our phone conversation.
With who?
Mr. Handte. Okay, and he said based on this unlawful act, he needed Reno Police Department's assistance. The unlawful act was based upon the jury verdict that he wanted us to enforce.
All right. What my question to you is, did you do anything independent of that, Mr. Handte saying that it was an unlawful retention of Mrs. Hillygus? Did you do any investigation in that besides the little conversation you had with Mr. Handte?
No, I have no authority to enforce a jury verdict.
No, but you do have authority to investigate people being held against their will, don't you?
In a care facility?
Any facility.
Relevant.
If there are allegations.
Hold on, Sir, there's been an objection raised as to relevance. Mr. Pitaro, your response?
Yes, Your Honor, the state offered into there that they did not request anything. The deputy chief has said that it was a civil matter, not a criminal matter, or at least obviously the import of that is. And I'm asking him specifically, based upon being advised that it was unlawful, isn't that generally a function of the police department to investigate unlawful detentions and people being held against their will?
Here I invoke the rule of completeness, which we just skipped over in the relay of the testimony, which is he requested Soto to join him and Hillygus as a show of solidarity in going there to enforce a jury verdict. Show of solidarity does not an investigation warrant or is not calling for an investigation. So it's important that the court recognize the context of it. My objection is to sort of the broad sort of authority of RPD, not applicable here.
Well, I think we have had numerous discussions and questions about that, so I will allow the answer to the question.
Isn't it the function of the Reno Police Department to investigate if people are held unlawfully?
Yes.
And isn't it also their duty as police officers if someone is being held against their will?
Yes.
Okay, I have nothing further.
Anything else? Oh, I'm sorry, Mr. Evenson.
Oh, that's okay, Your Honor.
My apologies.
No, that's all good. So, Deputy Chief, I want to explore this concept that you're speaking of briefly about the Reno Police Department not enforcing jury verdicts.
Objection scope.
It's been discussed 3 times since I asked any questions.
No, it was discussed in direct on cross. It was not this. It was rebutted on my redirect,
And I'm responding to his redirect.
Well,
I haven't had a
that's how
redirect.
scope works. That's how scope works. You ask.
No, but
I think at this point, it has been recently discussed in redirect. I will allow it briefly, but counsel, I want to avoid any repetition in questions that have already been asked and
Understood.
answered, please.
you indicated that the Reno Police Department does not enforce jury verdicts. Can you explain to me the difference between a jury verdict and a bench verdict?
I cannot.
Are you telling me that Reno Police Department does not enforce court orders?
We do.
Okay, so explain to me the difference between a court order and a verdict.
I can describe to you the court orders that we do enforce, the TPO, EPOs, emergency protection orders, temporary protection orders, but we do not enforce the order that he claimed to have, a jury verdict.
Well, you never saw it,
How
right?
he described it.
You never saw it, did you?
I did not.
Okay, so in terms of enforcing a jury verdict form, are you informing this court and the community of Reno that if somebody approaches you with a divorce decree and that divorce decree says that so-and-so is supposed to get property and Reno Police Department is supposed to stand by for the transfer of that property, you're not going to assist in that?
We would assist in
Objection to the argumentative, inflammatory nature of the question.
I'll rephrase the question. If a divorce decree is presented to your officers that says a property transfer is supposed to take place pursuant to this court order or decree or judgment, do you enforce that?
It all depends.
It all depends on what?
And did that decree originate in this jurisdiction? Do they want us to transfer property in the city of Sparks or the city of Reno?
Well, assuming it's in the city of Reno, assuming it's in your jurisdiction, assuming the house is next door to your police station.
Again, with the speculation and argumentative.
I'll withdraw the question, Your Honor. I've made my point. Thank you.
Anything else, Mr. Stege?
I would ask the report of Deputy Chief Miller be marked as it was shown to the witness. And I have one question. Deputy Chief was...
Marked as a court exhibit? Is that what he's...
Right. So it's in the record as to what was shown to the man that was used to refresh his recollection.
As long as it's not being introduced as the evidence and it's only for demonstrative purposes, I have no objection.
And that's my understanding, it's only for demonstrative purposes to make a note in the record. It's not admitted into evidence. It shall be so marked.
Thank you. And Deputy Chief was
I alluded in a question to the completeness of the statement was that because of the abuse or neglect or the woman being held against her will, that the request was for a show of solidarity from RPD to enforce the jury verdict. Is that correct?
That is correct.
Thank you. And that concludes my questions of the witness.
Any other recross based on that single question?
No, thank you, Your Honor.
May this witness
No,
be
Your Honor.
excused, counsel?
Yes, thank you.
Yes, Your Honor. Yes, Your Honor.
Thank you, sir. You may
Thank
be
you, Your Honor.
Mr. Stege, your next witness.
Or may I have a 5-minute recess?
Certainly.
Answer the call nature.
Certainly, we will be in recess for 5 minutes.
All right.
Counsel, and for those of you in the courtroom, the bailiffs made me aware during the brief break that apparently there's going to be a testing of the emergency broadcasting system sent to everyone's cell phones at approximately 11:20. So, in order to minimize the disruption here, if everyone could please make sure at that time their phones are off, so that we don't hear the blaring of the emergency broadcast test throughout the courtroom interrupting the witness's testimony, that would be very much appreciated.
Guys, that sort of defeats the purpose of the emergency broadcast.
But you've been so warned just now. It shall be tested. Mr. Stege, your next witness, sir.
Ms. Renwick, please.
Your Honor, could we address that issue now?
If you want, sure.
Yeah. Your Honor, there's been the issue of an absent witness, and we sent an email up to the clerk concerning if this would go into a second day as to what the court was going to do. And I'd like to know because I'll catch a plane out tonight, we'll catch a plane back to Las Vegas tonight, which is what I'm assuming we're going to do, but I'd just like to know that for, you know.
So, in the event that we can't finish today, obviously we'll have to schedule another date and time. I don't know whether we will or will not be able to finish today, but I assume it would not be tomorrow. My understanding is folks are unavailable tomorrow. Correct, Mr. Stege?
That is correct. In some emails leading up to today with involving court staff, that was indicated. So, Mr. Pitaro should not worry about being able to leave tonight.
Does that answer your question, Mr. Pitaro? We can schedule another date and time.
That's fine, thank you, Your Honor.
Okay. Mr. Stege, you had indicated the name is Renwood?
Redwick.
Renwick, thank you. Good morning, ma'am. If you could approach the witness stand here, and then once you get there, I will swear you in. So please, come right around this way and step into the well there, and then once you get there, if you could raise your right hand and face me, please. Do you promise the testimony I'm about to provide will be the truth, the whole truth, and nothing but the truth under penalty of perjury? I do. Thank you. Mr. Stege?
Thank you, ma'am. Please state and spell your name.
Robin Renee Renwick, RBIN-RENAE-RENWICK.
Okay, and I think the court wants us, we're gonna keep our masks on for the most part.
Yes.
Do you know a person by the name of Roger Hillygus?
Yes,
And how do you know him?
it's my brother.
Do you know Susan Hillygus?
Yes, that's my mother.
I'm gonna talk to you about how your mother came to be at the Stone Valley care home in leading up to this case. Can you please tell us how that happened?
I don't know how far back you want me to go, but in 2016, in the spring of 2016, there was a court petition for me to be co-guardian with Fiduciary Services of Nevada, and that was granted by the court. So at that point, I was co-guardian, placed in the position to be co-guardian.
And this resulted out of
Your Honor, objection. I'll withdraw it.
out of a long history of litigation involving yourself and your
Your
brother.
Honor, that's a leading question, I object.
Well, what answer does it obviously call for?
The
Is it yes or
presumption
no?
is that there was litigation that led to the guardianship. That's not true.
Well, that is true, though.
Well,
Just wait till the questions are posed, if you may, Miss Renwick. I'm sorry.
So it's not,
I think it can certainly be asked as an open-ended question. Go ahead, Mr. Stege.
how was it that it came to be that the court issued an order directing you to be the co-guardian?
In 2014, all the legal aspect of this began with my brother was the trustee of the Hillygus Family Trust. And then in 2015, he was removed as trustee of the Hillygus Family Trust. And I was in then 16, I was put in position as the co-guardian of my mother. And at that point, Fiduciary Services was my co-guardian, and they were the trustee of the Hillygus Family Trust.
And in the meantime, okay, and so what was the status of the guardianship leading up to this case in August of 2019?
Your Honor, I'm going to object on the best evidence rule. There needs to be legal documents presented to this court of a certified nature to support.
I move in Exhibits A through D, certified copies of.
Well, I haven't seen those. When did you get
Your
these?
counsel in those.
I am aware of that, but I'm entitled to see documents you're introducing into evidence.
And counsel, let's just take this step by step. If Mr. Stege's proffering something into evidence, and he can certainly reference what the state's exhibits numbers are.
Actually, I'm not moving it to that bin yet. And I respond, best evidence rule.
If he
That's
has the
no
documents
application.
and he intends to introduce them, that solves my objection.
Counsel, I've asked you before, please do not speak over the top of each other. I cannot hear what either party is saying when you're both speaking at the same time.
Sorry, Your Honor.
I believe Mr. Stege's question was about this witness's personal knowledge. I will allow her to answer that based on her personal knowledge at this point.
I think she's already given, well, in the meantime, what was, how was that your mother, sort of in a legal context, came to be living in the home?
When Roger was removed in December of 2015 as a trustee and guardian of my mother by the courts, they removed him. At that point, I was put in the position as temporary trustee of the Hillygus Family Trust and temporary guardian of my mother. My mother was still living in her house at that point, and Roger was living at the house with her. The judge allowed Roger to stay as my mother's caregiver at that time, although I was the temporary guardian. This was awaiting the hearing that we went to in spring of 2016. At that time, when Roger was the caregiver, my mom had a problem with her heart, and she was admitted to the hospital in January of 2016. And my brother was the caregiver, and I was the co-guardian. So at that point, I was very involved in all of the proceedings at the hospital. So when it was time to pick my mom up from the hospital because she had a pacemaker surgery completed and put in, when it was time to pick her up, I communicated with Roger through Family Wizard, and I said, Mom will be ready to be picked up from the hospital at this time. And his response back was, and he's being paid as caregiver. He's living in my mom's house, and he is being paid a monthly amount to care for my mom, even though at that point I was the guardian.
That's per the proceedings?
Yeah.
Okay.
Roger refused to come and pick my mom up from the hospital, and he said, "You take her home with you." So at that point, I took her back to my house, and she continued to live there with me until the spring of 2016, when we had the next hearing. And I was, at that point, no longer the temporary guardian of Susan Hillygus. I became the permanent co-guardian of Susan Hillygus. And at that point, I asked Fiduciary Services to take the role of being the trustee and co-guardian as a private company.
Okay. And so what was the status of the guardianship trustee question leading up to the date that the incident in this case occurred?
So at the time that the incident occurred in August of 19 at Stone Valley, I was the co-guardian of Susan Hillygus, my mother.
And
Fiduciary Services was also a co-guardian with me.
And as a result, the two of you, the co-guardians, were responsible for what decisions?
We were responsible, as co-guardian, we were responsible for all of my mom's healthcare, safety, medical. We were in charge of all the decisions for my mother.
And from how was it, or was there some sort of legal action that occurred that resulted in your mother, you said she had been living with you, to living at Stone Valley? How did that occur?
The courts, we petitioned the court and asked permission as co-guardians to place my mom at Stone Valley Alzheimer's facility. And there was an order put in place that my mom, by court order, could be placed at Stone Valley.
And she subsequently was?
And she was in June of 2016.
And per that order, there was visitation permitted or outlined.
Part of the reason the judge approved the placement of Stone Valley is because it would allow my mom to visit both of her children. That was a place that both children could come to see her.
And the court order outlined that you got either even or odd days and your brother got the opposite.
Right.
And there she was to remain.
Right.
This is an Alzheimer's care, or she was put
Your Honor,
there for-
objection, leading question.
I don't think Mr. Stege finished the question.
What was your mother's sort of capacity, mental capacity, and ability to care for herself at the time, or leading up to her placement at Stone Valley?
My mom's capacity with Alzheimer's just was continually declining. So at the time, she was placed at Stone Valley in 2016. At that point, she was already incapacitated and described that way by the doctor.
I'm going to object to that being hearsay, Your Honor, for the purposes of this hearing.
I'll ask it a different way. Did the court adopt any findings of any doctors in permitting the placement of your mother into the home?
Yes, my mom had a brain scan and she had a medical diagnosis.
Your Honor, objection, that's non-responsive. It was asked what was placed in the order, not what doctors did.
No, it was asked of what the court findings were in relation to the doctor.
That is correct, and that's why it's non-responsive.
I will allow the answer.
My mom had been diagnosed by a neurologist having Alzheimer's, and she had a diagnosis, and that information was addressed in the courts about her medical condition with Alzheimer's, and which was continually declining.
And did that, leading up to her placement, did her medical condition affect her ability to do day-to-day activities, sort of care for herself, things like that?
Yes, she could be left alone. She needed constant care and supervision.
And were those findings placed before the court or those issues placed before the court, leading up to the court allowing her to be, or placing her there?
Yes, in order, before the court made that decision, we had a Dr. Rubin come out and do evaluation of my mother. We also had Creative Elder Solutions, I think, come out and talk about and do an evaluation of what her day-to-day needs were, as well as she had a neurologist, Dr. Spivak. So there was a lot of medical evaluations done before the courts approved my mom to be placed in Stone Valley.
And your mother's age around this time was she?
I think she was, at the time of placement, she was 76 or 77.
Older than 60 years old?
Yes.
Okay. So let's go moving forward. Once your mother is placed there, this visitation issue, do you know if Roger visited your mother at Stone Valley?
Objection calls for hearsay response unless she was personally there.
Well, it's not hearsay if it's a statement of a party opponent. It's also not hearsay if it's within her personal knowledge.
Steve, the question I believe is being asked about her knowledge. I think she can answer about her knowledge.
I visited my mom as frequently as I could, multiple times a week. I tried to get up there daily or every other day. So I was always made aware.
Objection, hearsay.
Frequently, the...
Hold on, ma'am. Let's address the objection.
Okay.
That's all right. Mr. Stege?
The court just allowed her to testify to personal knowledge or her understanding of the situation.
I agree. I think she can testify as to what she was aware of regarding the situation.
Well, I was aware and informed by Stone Valley a few different times when there would be problems. So,
Your Honor, again, it's non-responsive to the amount of the visitation that my client is using. Now it's going into allegations of problems which are being offered for the truth of the matter asserted. I have to object. This is entirely hearsay. She can say whether or not he knew he visited or not, but anything else, I have to continue to object.
Ma'am, if you would just limit your answer to the question that Mr. Stege asked, it was regarding the visitation.
what was the question? Am I...
Aware of whether your brother would in fact visit your mother once she was placed in Stone Valley?
There were times, yes, that I was aware he would visited her.
And the sort of even odd, was that schedule kept too?
No, he was allowed to visit, anytime he showed up, he was allowed to visit her. They never enforced the even or odd, and I was fine with that.
Did you ever, from the time she was placed there until the incident in this case, go to visit your mother and see Roger Hillygus there?
Yes. The last time that I saw Roger at Stone Valley was in July of 2018, 1 year before the incident.
Okay.
At that point, he was with another man, and they were saying things to my mom that by the court order, he was not supposed to be discussing with my mom.
Such as what?
I'm gonna get you out of here, Mom. Robin put you in here, and we're gonna get you out of here. Don't worry, we're gonna get you out of here. You shouldn't be here. This is ridiculous. And those were discussions, none of that was to be discussed in front of my mom.
Do you know who the other person was?
I have a picture of him, but I think I know the name, but I can't bring it. I can't remember right now.
Okay. Any other time where you would visit or go to visit and you would see your brother there at Stone Valley?
That's the last time that I saw my brother at Stone Valley. I don't believe that he had been there after that visit. But they had to call the police. They asked him.
Your Honor, objection. hearsay.
And ma'am, just, please respond only in answering a question asked from one of the attorneys.
Okay.
There wasn't a question posed. That's all right. I know this is difficult. Go ahead, Mr. Stege.
And so, do you have, in this sort of the last year, do you have an idea? Do you know how often your brother would visit?
To my knowledge, he hadn't been there once in the last year, from July of 18 to August of 19.
Okay, and then leading up to this event, your mother being removed or taken from Stone Valley, do you know the last time you were with your mother at the home before she was taken?
I was there that morning.
Okay, and you had earlier mentioned her sort of capacity, mental state, you know, ability to care for herself. What was her condition then on the date this happened, as opposed to when she's initially placed there after the court hearing the evidence from the doctors?
Can you ask that one more time?
Yes, had your mother's condition remained the same, improved, or deteriorated since she was placed at Stone Valley in the spring of
Oh,
18?
from 16
From
to
16
19.
to 19, yes.
It was a gradual decline.
And so, for example, what did your mother recognize, was she able to recognize people, including yourself, when you would visit leading up to August of 19?
She could recognize people, but she couldn't verbalize that. So I could tell from her personal reaction, her smile, you know, a hug. She recognized me, but she could not say, "Hello, Robin."
Was she able to speak?
Garbled speech. She could not ask a question, and she could not answer a question.
And as her guardian, you were aware of the medication that she was given and aided in making medical decisions?
Correct.
And were you in fact responsible for medical decisions?
Yes,
And was your mother on any medications?
she was.
Did those medications, how often in one day would she have to take medications?
2 to 3 times a day. She had an anti-anxiety medication that they would add as needed, so she could take that a 3rd time, but most of her medications were morning and night.
Your Honor, I move to introduce the aforementioned exhibits.
Your Honor, I object, they're not certified copies.
Mr. Stege?
Certified copy, I know Mr. Evenson doesn't practice a ton here, but here are certified copies all under the seal of the court, as well as the same case number.
They're not, I didn't.
With the exception of a number of them being copies of originals.
Your Honor.
Which, as we know, under the best evidence rule, a copy is the same as an original.
The method for introducing a court record, as the court I believe is well aware, is that you either have a certified copy or you have to go through the foundational requirements of introducing the record. That has not been done in terms of the foundation, so I have to object. And they're not certified copies, so they're not automatically admissible. Whether or not they're actual copies of whatever they're copies of, the rule about certified copies of court records is in effect for a reason. And he doesn't have certified copies, so I have to object.
So addressing the first part, I do believe some foundation can be laid, Mr. Stege, to the introduction of those things.
Ma'am, do you recognize, well, as a party to or being involved in litigation involving that you just described, you're familiar with the filings in the court, correct?
Correct.
Will you please review those documents?
Mr. Stege, for the court record, can you indicate what they are marked as?
It's alpha through delta, A through G.
Thank you.
I'm familiar with all of these.
And do you recognize those to be various orders in the case that you have just described?
Yes.
Move to introduce the exhibits.
May I voir dire the witness, Your Honor?
You may.
Ma'am, with regard to the dates on those documents, what are the dates on each of the documents, and what is each of the documents identified as?
The first date is 6/17/2016. Order approving sale of real property. Order regarding removal, appointment of counsel for Susan Hillygus.
Okay. And what's the next one?
The next one is dated 12/23/2015. Order removing guardian and appointing temporary guardian of the person.
Okay. Next one, please.
1/19/2016. Order confirming Robin Renwick as temporary guardian.
And the next one, please.
4/18/2016. Order after February 9th, 2016 hearing.
Okay. You haven't seen those documents today, prior to today, for several years, have you?
I haven't, I've seen these documents.
I didn't ask whether or not you've seen them. I asked whether or not you've seen them in several years. Obviously, you've seen them.
Objection, argumentative.
I'll rephrase the question.
As well as irrelevant to the voir dire
It has
question.
not been several years since I've seen these documents.
Okay, so when was the last time before today you looked at them?
Objection, relevance.
So I will allow some of these questions regarding the documents on voir dire.
I would note that if these were certified copies, we would not have to go through this process, Your Honor.
I would note that they are copies of the originals. They bear the seal, they bear the filings of the court. A number of them are certified, as a matter of fact.
Your Honor, if Mr. Stege is making a representation to this court that a number of those documents are certified, I challenge him to show us that right now.
Well, I don't want to engage in this.
No, he made a representation as an officer of the court, as an agent of the state of Nevada, that those are certified records. They are not.
Hey, agreement we.
That's one. Where's the rest of them?
Counsel, counsel.
That's one. Where's the other three, Mr. Stege?
Mr. Evenson
Sorry.
and Mr. Stege. Please behave civilly. Let's take this step by step. We can address these issues in a civil manner. Mr. Evenson, in a civil
Apparently,
manner,
I'm sorry, go ahead, I'm sorry.
in a civil manner, please
Yes.
state your objection.
Thank you, Your Honor. Apparently, document A is a certified copy. This is an order approving sale of real property, order regarding removal, appointment of counsel for Susan Hillygus. That meets the statute, and I believe it is prima facie authenticated, and I do not believe I have a valid objection to this document.
And therefore, I ask that you withdraw the insinuation that I made any misrepresentations to the court about.
Except about the other three documents that are not certified.
We're going to take it step by step.
Thank
My
you.
understanding is that there is not an objection to document A.
That is correct. I'm going to approach the clerk for submission to the court.
All right, it shall be so admitted since there's no objection.
Thank you.
And Judge, I'm sorry, are we doing this as State's Exhibit A, or is this now Defense Exhibit
No,
A?
it's state's exhibit.
In all states, and I'll need them back for.
Thank you.
And then, with regard to the other three documents, Your Honor, they are not certified. And it was my mistake for missing the one that was certified. I went from the back and I didn't see any of them certified, so I apologize. But the other three are not certified. With regard to my question of her, Mr. Stege is arguing that they are copies of file stamped documents. That's not true. The only thing that we know that is file stamped is the first page. The rest of the document has to be verified as being a true and accurate copy of the record of the court. My point in asking the question of this witness is whether or not she can authenticate that, which clearly she cannot. And because of that, none of these documents come into evidence today. That's the point of the questions. That's the point of the argument. That's why I was asking.
So, if you want to argue the issue of authentication now, we can do that. If you have more questions regarding that on voir dire, I'll allow you to do that before we have the arguments regarding authentication.
I do have a couple more questions if I can proceed.
Please ask those
Thank
questions,
you.
and then we'll have the argument about authentication.
So, again, to be clear, you don't have those documents memorized. You don't know what's in them. You don't know what's in the court record versus what's in those documents, do you?
I'm familiar with what's in those court orders.
I'm not asking about whether you're in general familiar with them. I'm asking you whether or not you can state under oath today that those documents are exactly the same as what was filed with the court whenever, or that they're exactly the same as on file.
No, I cannot.
Thank you. Your Honor, because of that, there can be no foundation laid and they don't come into evidence.
Mr. Stege, I'll allow you to object or answer to the objection regarding authentication.
It should be admitted, the line of questioning goes to weight, not admissibility. They are additionally corroborated by the testimony of the witness, and so they have to be admitted.
So, the burden of authentication, courts have previously ruled, is slight. Certainly, parties can argue as to the genuineness of those documents at a later point. But for purposes of this hearing, I do find that evidence sufficient to support a finding that it is what the proponent claims to be has been done. So I will admit those documents stakes B, C, and D.
And for the record, Your Honor, I do object. I know I've objected previously, but I just want to be clear. Thank you.
Ma'am, additionally, within the litigation or the question of the home loomed large, correct? Your mother's home.
After that last part?
Your mother's home was also a subject that the court dealt with involving the guardianship.
Yes.
And leading up to this, did the court order that the house be sold?
Yes.
And was your brother in agreement to that?
No.
Your Honor, what relevance does this have at this time?
Motive.
I'll allow it.
May I have,
And intent, which is really intent.
may I voir dire the witness briefly?
Well,
I'll withdraw the question, Judge. That's fine.
the answer to the question was yes. There's not much to voir dire on. That's a different tactic.
Go ahead, Mr. Stewart.
The court had, your brother was not in agreement to the sale of the home.
Correct.
Was there any delays in getting to the point where the court had allowed the sale of the home?
Your Honor, again, I object as to relevance, and if I may expand on that.
All right.
The alleged incident that she's referring to is from the time of the sale of the home, which was in 2016 and 2017, as the order in front of you that you've admitted indicates. I believe it was even, the order for sale was from June of 16. We're talking about an event 3 years later. Mr. Stege is attempting to say that there's a motive on the basis of that order 3 years later. I understand the burdens of evidence here, I understand where we sit today, but at the same time, trying to draw something from an alleged incident 3 years before to an incident 3 years later to supply motive requires something more than bare testimony that is designed to make my client not appear profitably before the court.
And I'll allow Mr. Stege to answer.
To answer the objection or to the witness?
No, to respond, respond to the relevance issue a bit more than with one word, if you may.
Well, beyond the date of the order, this issue was ongoing leading up to Roger Hillygus taking his mother from Stone Valley. The order, as a result of the order, there, as I understand it, and I would expect the testimony to be a number of delays from Roger Hillygus, culminating in the sale being timed around the time that Roger took his mother from Stone Valley. And that's the target of the question.
That would need to be established by the dates, and that was where I was gonna go with my voir dire before it was cut off, was to show that these things took place years before the incident in August of 19 that the state is attempting to prosecute my client for. So I was just merely trying to say that there's not enough nexus between the two and get those dates out there before all the testimony comes out, and then maybe you can make a ruling on the nexus.
So Mr. Stege has stated the relevance adequately in my mind at this point. He's given the offer of proof of where he expects the testimony will go, so I will allow him to proceed.
And from the time of that the court first ordered the sale of the house, were there delays in its sale?
Yes, multiple delays
And from who?
from Roger.
And leading up to this date, August of 2019, what was the status of the attempts or the ability to, not the ability, the sale of the house? When was the house supposed to close? The sale of the house supposed to close?
We had a hearing that's scheduled the day after my mom was taken to approve the sale. The house had been listed, we had a buyer in contract, we had an accepted offer. We had to go to the court with that accepted offer for final approval, and it was scheduled for the day after the incident happened with my mother.
So that being the 9th, there was a hearing for the court to approve
The final sale.
the final sale of the home. And even up until this point, was Roger still against the sale of the home?
Yes,
And the monies from the sale of the home, were those going to be used for the care of your mother?
yes.
Where had Roger been living during this time that we were trying to get the house sold?
At the beginning, after 2016 order that said we could sell the house, Roger was still in the house for, I don't remember the period, until he finally had to be evicted from the house by the sheriff's department and the SWAT team.
And that was
Because he refused to leave the house.
despite the court
Despite the
orders
court's
against.
order.
Okay. And was your brother also at one time the guardian related to your mother's retirement? So historically.
Historically, when Roger was the trustee, he was in charge of my mom's PERS retirement and Social Security.
And basically financial
And the financial
issues. And that originally, when he was the trustee, that was set up by appropriate documents, correct?
Correct.
And did the court eventually, when he stopped becoming the trustee, where was that responsibility?
I sent all of when Roger was removed as the trustee and guardian of my mother, the legal documents were sent to PERS and the Social Security Department showing who the current active trustee and guardian were, and then those accounts were, those deposits were put into a bank account that the fiduciary had set up.
And so that, the result being that the financial aspect of your mother's care was then handled in this co-guardianship situation.
Correct.
And was your brother resistant, leading up to his removal, was he resistant to being removed in the financial capacity
Yes.
of your mother?
Yes, financial and of her personal person.
And in fact, leading up, let's say, in the month or months before this incident occurred, was your brother still trying to get back the powers of trustee, namely the financial issue as well as the house issue.
My brother went to the Social Security office.
Your Honor, I'm
and
going to
said-
object, that's hearsay.
And I would just direct you to answer Mr. Stege's question specifically.
Okay.
Leading up
It's all right.
to, let's say, the last month or two or a couple of months leading up to this, was your brother still attempting through the proceedings to try to get, stop the sale of the house and to regain his financial position in relation to your mother's affairs?
Your Honor, I'm going to object, that's a leading question, it supplies the answer as a yes or no question, yes or no answer.
I don't think that's a leading question.
Yeah.
I'll allow.
Yes, he,
What was he doing?
he went to, my brokerage, because I'm.
Objection, hearsay. He went to my brokerage, not that he went to her or anything else, it sounds like hearsay.
Well, so far, no statements have been relayed of the defendant, and if there are statements of the defendant relayed, those are not hearsay.
Don't hear that any assertions or statements have been made by what this witness is saying, so go ahead and you can continue your answer.
The 2 months, or 2 or 3 months leading up to the sale of the house, Roger tried to stop the sale of the house. He went to the real estate company. that I work-
Objection, hearsay, unless she was personally present at the real estate company.
We haven't heard the answer yet. The court just ruled, and so far it doesn't sound like an assertion. And so I think the court is certainly in the position to judge how to go forward and strike if necessary. Any testimony.
At this point, I believe she's testifying from her personal knowledge. If she's going to describe or state any statements of others, then I believe the objection regarding the hearsay is appropriate. But at this time, I don't think it is right yet. So at this point, it is overruled.
The broker at my real estate company called me in and asked me if he had been told I did not have the right to sell the house. He had been presented with documentation.
Your Honor, I object. This is all hearsay. Specific statements about what my client is allegedly saying to a third party who's not here to testify.
At this point, I think it is veering into the hearsay realm. Mr. Stege?
And I want to ask you, within the court proceedings, was your brother making efforts to stop this, maintaining that the sale of the house not go through?
Yes,
And additionally, was he maintaining in court, saying this in the months leading up to this, that he ought to be the trustee, reinstated as a trustee with the accompanying financial
he
powers?
frequently referred to himself as the true trustee of the Hillygus Family Trust.
Up until this incident,
Yes,
and what about after the incident,
even after the incident.
despite
Documents,
despite court orders to the contrary.
yes.
At the time, you were working at a real estate firm, correct?
Yes.
And with a person by the name of Ken Edmondson,
Yes,
who was he?
he's the broker.
And Jared Russell as well. Who is Jared
He's
Russell?
the operating manager.
And within your real estate company, you have email accounts sort of indicating that they're affiliated with this realtor business. For example, someone who works at a company called Allstate might have.
Your Honor, what are we doing here? I object, there's no relevance, talking about emails for companies?
So I don't think Mr. Stege finished his question yet, so I can't determine any relevance until I hear what the question at least is going to be. Mr. Stege, you want to go ahead and finish?
And I'll anchor this with Mr. Evenson related to documents related to, I think, count 6 or 7. For example, a person who works at Walmart might have their first initials at walmart.com.
Yes,
Was the place that you worked at the time had a similar structure for their email system?
yes, all of us had our name and our information.
And without revealing the content, were you later at some date forwarded emails from the two gentlemen I just mentioned from addresses affiliated with the company?
Yes.
And without revealing the content, were you able to observe the email of Roger Hillygus within the chain that was forwarded to you?
Your Honor, I'm going to object. There's no evidence it's Roger Hilligus's email. There's no evidence that Roger sent this alleged email. It's not relevant. It's hearsay, all the above.
I believe the question was just the name appear in the email, and for that, I think that it can be answered, so I'll allow it. Go ahead.
Did you recognize within the forwarded chain, the email address of your brother, Roger Hillygus?
Yes.
And were you familiar with that address from being involved in the litigation involving your mother?
Yes.
And in fact, was that email address one that would be used by him within pleadings before the court?
Yes.
And one, at this point where you and your brother...
Your Honor, I'm going to object to Mr. Stege continuing to testify and supplying leading questions to the witness. She's answering yes or no questions. He's supplying all the evidence. She's just going yes, yes, yes.
The question can still be open-ended and have a yes or no answer. It doesn't have to necessarily be leading. So, Mr. Stege, I'm going to overrule the objection at this point, but I will caution you to just ask open-ended questions.
Yes, Your Honor. Had you and your brother around this time been emailing?
Back and forth? No.
Okay. But was there any history of you two?
Past, yes.
And can you tell us about that? What was that history like? Historically, had you used this same email address that you saw with?
Yes, that's the email he's had from years back.
When, moving forward to the 8th, did your brother ever contact you that day?
No.
Including after you took your mother?
No.
Did you ever see the pleadings from the court related to filings that were made by your brother on the 8th of August 2019? Specifically, this claim of a jury verdict.
Yes, I've seen that.
Those documents, as you look at this packet's been marked entirely as E. Mr. Evenson, will you please take the opportunity to review these?
Be happy to. Thank you. Yeah, sure. I suppose you should too. Yeah, absolutely. Your Honor, for the record, I'm giving them to Mr. Pitaro to review as well.
Your Honor, to introduce proposed E.
Any objection, counsel?
My only objection is to the numbering, Your Honor. There are about 7 documents contained in there as one exhibit, and they have multiple different filing dates. They were not all filed on the same day, so I think it's inappropriate to introduce them all as one exhibit. I would request that they be re-lettered at the appropriate time. I don't want to inconvenience staff or the court and have to go through that for a few minutes right now, but I think they do need to be re-lettered at some point as individual exhibits.
That's without objection.
All right, so Mr. Stege's agreed
I'm happy that
to go ahead and do that.
we'll read
And for the record, Your Honor, these are all certified copies, and so I believe there's a presumption of authenticity under NRS 52 that prohibits me from going deeper into that. Thank you.
So I would actually prefer that if we're going to mark them differently, that we do it now so that the witness can have some clarity and all parties can be clear about which documents we're talking about. So Mr. Stege, if you can approach the clerk, she will go ahead and assist you in remarking those. However,
And I do apologize, because I asked the clerk to mark them this way, so that's on me.
it's all right.
And Jeff, would you be opposed to me marking it as E1, E2, like?
That is totally fine for me, yes. Whatever's easiest for the clerk.
Okay.
For ease of,
I think she still needs them.
no, for ease of use, I'm gonna make sure they're in, filing date order.
Gotcha.
Mr. Stege, is this was off, is this separate? States exhibits E1 through 9 have been marked.
And counsel, now that they have been marked as requested, are they also admitted at this point?
I believe because they're certified copies, my ability to object to them is rather limited. So I have no objection for the purposes of this hearing.
Thank you. They shall be admitted for the purposes of this hearing as marked E1 through 9.
And ma'am, these, the pleadings filed included, I'll note for the record, a, for example, at E4, a claim that there was a separate jury verdict and another, well, claim to undo all the orders that had been entered here in Nevada related to the guardianship, correct?
Yes.
Nothing further past